session, and I think that in my mind, ethics is so important in the business world, and especially financial planners, because of the rules that are posed by the CFP board to protect the integrity of the name Certified Financial Planners, that I try to have it covered as much as possible in a course like this. And one of the things I'm going to do is talk a little bit about ethics for board advisors and advisory councils, which again I hope many of you get the opportunity to work on. Ethics. Board members and advisory council members are fiduciaries and have a duty of putting the company interests before their own. And again, this is not the same ethics as other situations. Again, ethics depends on the role you're playing. If you're a CFP, you got the ethics there. If you also have a securities license, you have that ethics, or the insurance industry ethics standards. You have the ethics standards of your company, and you have your personal ethics. And if you belong to a local association, you have their ethics. So ethics is going to vary all over the place. And so you always got to say, okay, what ethics apply in this particular situation? And so I thought I'll talk about some of the major problem areas that cause ethics problems for people on board of directors and for people who are serving on advisory councils. And also, you might think about also for employees. You may have an employee or advisor be a competitor, and you must put a wall up between the companies. So again, going to my favorite example of having my restaurant get advice from the on my board or as advisory council from the best restaurateur in the area. That restaurateur, when he's working with me, has to protect my business, and he has to have a wall between that and his business that he owns or manages, and that is something that we have to face in the business world. That is also true at large companies. In fact, most large companies, you'll find the board of directors having members on it from people in the same industry who are chief executive officers or senior positions in the companies serving on the board of a competitor. And sometimes I wonder how that's done. But I have served on the board of, say, two companies who make sensor components for the government. And I actually found there was no problem as long as I remembered to keep that material that related company A separate from the information I gave company B, and not cross-fertilize them, because by cross-fertilizing, I'm many times taking proprietary data and giving it to someone else. So you really have to work on that wall. Company may be a client of the board member or advisor, and thus an arm's length relationship is required. If you're my client and I'm on your board, I have to forget about the fact that you're my client. I have to think of an entirely different role, and I call that role playing. I have a different role with my children than I do with my spouse, with my parents, and I have a different role at work. And the same thing is when you're serving as a board member or as an advisor member, you have a different role you're playing than as an advisor to them, as a consultant rather. And we may have corporate rules that are against public policy, which we'll talk about in a second, and that becomes an issue. You're on the board and they do something. Right now I'm thinking of if I was on the board of Wells Fargo the last few years and today, what would I do? And finally, responsible for actions of bad faith, fraud, or willful misconduct. Even though I'm not an employee of the company, I am responsible for any bad faith, fraud, or willful misconduct, which are very broad terms, obviously. The burden is on me to prove I'm not in many cases. There's a good reason why you have to have that liability insurance I talked about earlier. And I would say that for many people who don't go on boards of directors because they're concerned about actions being brought against them as board members. Many times when you sue the company, you also sue the board of directors, your advisory councils, all our consultants. It's a shotgun approach when a lawsuit to see who's got the most money that you can get out of people. As by far the major contemporary issue for board and advisory members is the rule for corporations in most states, saying that the purpose of the corporation is to act only for the benefit of the shareholders. That is a toughie because there's only a few states that allow for the board to include in the purpose of the company their employees, the environment, their customers, the local community. In general, most states, I think 34, 36 states, requires only for the benefit of the shareholders. This has been a big issue in classrooms in ethics, and it's certainly in states been a big issue. There are a lot of states who encourage, and society in general encourages companies to worry about the environment, to worry about the customers, and yet from a legal standpoint, they're supposed to only worry about the company. There's been law review articles on this, and in fact, in your textbook it has some examples we'll talk about in a minute. One of the textbook examples you had was Henry Ford has pointed out in the textbook, got in trouble for not pricing the automobiles as high as possible to generate the highest short-term profits. Instead, he wanted a lower price so everyone could afford to buy an automobile. Now, to me, it makes sense if I can get everybody, the volume will make up for in the long run, the lack of profits I'm making now by having the highest price possible. Again, that all depends always on what the judge says, and you never can predict what will happen. Now, what's the best interest of the shareholders? Immediate profits today or profits over the long run? And some judges might say the immediate profit today, obviously that was the issue with Ford. Other cases, they will not look that way. They'll look at what's the long run best interest of the shareholders. Our library has a copy of 42 Loyola Law Review, page 765 from the spring of 2009 by Anthony Biscani, titled The Double Bottom Line Consistency Statutes Protect Socially Responsible Companies Stuck in Revlon Land. It's if you want to understand the challenges we're trying to do social responsibility in a state which requires the company to only be concerned with the ownership, this is a great article to read. In fact, I think it'd probably be a good topic if we were in a classroom to spend 2 or 3 hours or even longer on, because again, it's a very complicated topic. Do you follow the ethics or do you follow the law? Do you follow public policy and public demand that the environment being protected, or do you follow what's best for the owners? That becomes a real issue. Second major contemporary ethics issue is board and advisory always concerns how far they can apply social consciousness in their duties. And California is the only state currently allowing a business to incorporate as a flexible purpose corporation. Now, this is also described in the book, in the law review that's in our library, 47 Loyola Law Review 619 by Ross Kelly, and the article called Emerging Need for Hybrid Entities, Why California Should Become the Delaware of Social Enterprise Law. This is also found in your textbook. Again, an excellent article. I think if you read this law review and the one we had on the previous slide, you have a much better appreciation of how complicated it really is to be on a board of director, and the ethical issues become very obvious also. Times should your personal ethics override the law? That's something that, again, we could spend hours on in a class. And unfortunately, the way we're set up with this lecture, we can't, but maybe we can cover it in the chat room. And then finally, ethics summary. Anybody serving on the board of council must recognize the legal rules for the corporation required by the state of incorporation. For example, many companies are incorporated in Delaware, New Jersey, Arizona, Idaho, as opposed to the more challenging states to incorporate in. And that may be an entirely different state, and well, in most cases it is, than the main office. Main office, for example, for me in California would be in Los Angeles, and yet I'm probably incorporated in New Jersey. and then where I have operating. I may have an office in Arizona as well as California. So all of those states have an impact, and what rules do I have to obey in each of those situations? Again, I would go back to those law review articles for you to look at. And I say, in many cases, personal and professional ethics standards must be set aside. Legal advice is obviously needed in those type of situations, and which again is something that we have to face. You're not going to get away from having the lawyers help you. And I always have the position that when I start a business, I have to have a lawyer that's familiar with the business and who will work with me. And again, I may talk to him once a year. I may need him every week. We never know what's going to happen. But having that relationship there so I can get to him something. Having served on board of directors and advisory councils, I find the same thing. I need to get legal advice in many cases, so I know exactly what my responsibilities are and what I can and cannot do. Our conclusion for this module is there are various types of agents, and each has its own responsibility and rights. The role of board members and council advisors have a fiduciary responsibility, and we can hold personally liable for their actions or inactions. Again, there's board of director liability insurance that is available and should be used. And then finally, personal and professional ethics standards may be affected by state laws when dealing with corporate entities. I might also, personal ethics many times is affected by what you have to do, and that again becomes a judgment call as to what to do. And when in doubt, if there's a legal issue that's involved with the ethics, that's when you call in your lawyer.